Hello, honorable members of the class, and let's go to the Gauteng High Court in the Senzo deletion trial. I told you guys this morning that Judge Rata is yearning to make a ruling regarding 375. Docket 375, and it's good news. And I will say something first before we get to the good news. You know, I still believe that Judge Rata or that particular courtroom has created a monster out of Advocate Baloyi, who completely disregards the Constitution of the Republic of South Africa, particularly Section 35 of the Constitution, which this very channel has been preaching about. As long as you have accused people in that courtroom or any courtroom in South Africa, Section 35 of the Constitution is lingering over, making sure that it is adhered to by the presiding officer and the officers of the court, that is the state and the defense, so that the accused, they have a fair trial. And we've seen how Section 35 of the Constitution has been manipulated, ignored, because somehow I feel like Judge Rata has an issue. Even when he was quoting Section 35 of the Constitution, or the Constitution for that matter, he first laughed like as if like, oh, I can't believe I'm about to say this type of situation, because for some reason in his mind he's still back in the days. He's still back in the days, even though he had stopped making a decision based on old authorities or precedences or whatever it's called, to now coming at least as close as possible to post-1994 authorities. Well, this morning, the monster woke up and said, I am going to give a warning to the defense, my colleagues. And I was like, a warning? Okay, I gotta hear this one. And he goes on to say how documents of another docket or something like that must not be used unless the person that are going to be mentioned are going to be called on the stand as witnesses, knowing fully well that the defense is at the state's mercy when it comes to witnesses. He knows that. And then, of course, the witnesses the defense can have are those that are going to speak in their favor, not against the state. So obviously, he is not going to say, oh yeah, okay, let me write a subpoena for you to call, for example, Absalom Zungu, whom, by the way, Mr. Baloyi has been using to build his case, and on the basis of hearsay. Not once did he call Absalom Zungu to the stand. But no, the defense can use the same principle. And I am so glad that Ntanzi is awake in that courtroom, because he raised his hand to his representative and said, excuse me, if we can't make reference of people that are in 375 as part of the defense, then why then Mr. Zungu was mentioned in the state's case, as well as other people who have who are deceased? And I did ask that question many a times on this channel, like, why are we using statements of people that are gone? Like, I'm talking dead. At least they could be announced to the court that they are late, and here's the evidence of the status right now. And then Bongani was asking, like, I'm sorry. Oh my God, I'm so sorry. I don't know. Okay, let me just mute this. I apologize. So he wanted to know why we can't use what references of other people, dead or alive. And then Judge Rata is like, yeah, I mean, I did ask about the compiler of the photo album that is in 375. Is he alive or dead? Ms. Mshololo confirmed that he's still very much alive, and she intends on calling him when it is the defense time to rebut basically the state's case. I was like, yeah, and I love Mr. Mnisi's response to Mr. Baloyi, and he said he's not going to accept. He said it's an advice. It was not an advice, Mr. Mnisi. It was a warning. I wanted to hear what the consequences of actually continuing were going to be coming from the state. How they were going to be punished. Because when you give a warning, there's a consequence if you repeat the offense, right? So Mr. Mnisi was like, this is nonsense. He also quoted his own provisions of Evidence Act of 1988, I think section 3, the chapter 3, section 45 or something of that nature. I was like, okay, I didn't know about this. This is interesting. And then Ngumalo came back and said, basically, all that it says that provisionally accept the here evidence until the person that has written that statement fails to come to court, and then you can strike it off the court record. But it can be provisionally accepted or admitted by the court. Judge Rata wanted to argue, it's like, is it true though? Which kind of like got Mr. Ngumane a little bit confused, but he stood on his ground and said, this is what I understand about this provision, and I'm going to stick to that. So Judge Rata then at the end of the day had to make a decision after hearing Baloyi's warning as well as the defense's response. Mr. Ramusipili was not happy with how they were ambushed by Mr. Baloyi, because the discussion was about the photo album, whether it's going to be used or not, which Mr. Ramusipili said he was not going to use it any longer because it's immaterial to his cross-examination to Geninda. Then Rata made a decision, and Rata, I was like, oh, so now you know the Constitution exists? Now you know, because I've been saying this is an unfair trial. It's unfair trial on the basis that the Constitution was disregarded in this courtroom as far as I have observed. And now I think he realizes that, wait a minute, I've taken decisions before and never once have I quoted out of the Constitution, especially section 35 of the Constitution, because we have two so-called confessions that were obtained, and yet section 35 of the Constitution was violated badly by the police officers, but it was still admitted. Why? Because there's a disregard for section 35 and the Constitution of the Republic as a whole. And so today he's like, well, according to the Constitution, in order for the accused to have a fair trial, all documentation, whether it's on paper, audio, or film, they all have, they're fair game basically for the defense to be able to have a fair trial. So Mr. Baloyi is partly correct, but the Constitution overrides that privilege that he tried it this morning. I was very impressed with that. I was like, good, very good. Now we are seeing the light that the Constitution of the Republic of South Africa must always be present in any court proceedings in the country. It was quite interesting when Baloyi was quoting a civil case that happened in the 1970s, I think 1971, about some dude, and this documentation, this must not be included. I was like, whatever. Whatever, Baloyi, you are trying it. He was trying it for real. And anyways, after Mr. Rata Mokgoatleng made a judgment that all documents that the defense feel like they need to use, whether it's out of an evidence that is still being investigated or a one that has been discovered and actively in court, it shall be used by the defense. That also includes the photo albums that Mr. Ramusipili wants to use. He can go ahead and use them. So in my understanding, if the defense want to quote from 375, they can. Meaning 375 is now active in this particular case, and I'm quite happy with that. That is what I was saying in this in the morning's video, that I felt that Ramusipili has missed an opportunity to have 375 active in this court, and now it is. He can use it, and any of the defense lawyers, they can use 375 whatever is in there as part of the defense or rebutting the state's case, etc., and so on. And that to me makes me quite happy, which now also the defense can even argue the arrest of all 7 people that were with Senzo Mayor on that particular day. But let's hear what they have up their sleeve. So before they get back to court, I just thought, let me give you my thoughts about Advocate Baloyi trying it this morning with a warning. A warning. What was the consequence if they did not listen, Mr. Baloyi? Is that what I wanted to hear at the end of your submissions or whatever it was? Ambush. Ambush. And I saw he was not happy with the ruling against him. And that, guys, I shall see you later when we go for a long adjournment. I just thought, let me just have this one and say, Mr. Rata, you created a monster out of Mr. Baloyi by disrespecting the Constitution. He has sat 4 years in a constitutional law class, and I don't understand why he's not putting it into practice. Other than that, guys, please don't leave this video without liking, sharing, commenting, and subscribing. And if you like the family, you are going to click the bell notification so that you can come with your two IQs, rub them together, and also have your own opinions about what is happening in the North Gauteng High Court. See you later, guys. Goodbye.